Hello and thanks for joining us on Chicago Tonight. I'm Brandis Friedman. Here's what we're looking at. The father of the alleged Highland Park gunman pleads guilty. What his sentence looks like. Meanwhile, jury selection begins in the corruption trial of former Alderman Ed Burke. Chicago workers would get 10 days of paid time off under a new proposed ordinance. Labor groups and the business community weigh in. And the state's second most populous city is accused of playing favorites with companies at its airport. But first, some of today's top stories. Drama at City Hall as City Council's most powerful member resigns from the positions that gave him power. 35th Ward Alderman Carlos Ramirez Rosa has resigned as Mayor Brandon Johnson's City Council floor leader, as well as chair of the Zoning Committee, positions he's held for just 6 months. In a statement, Ramirez Rosa apologized for a, quote, disrespectful interaction during a special City Council meeting last week where he scrambled to physically block 37th Ward Alderwoman Emma Mitz and other alder people from entering council chambers. Today, 31st Ward Alderman Felix Cardona said that Ramirez Rosa grabbed his shoulder and used a threatening tone while whispering in his ear that he should not attend the special meeting. That meeting centered on the city's efforts to respond to the migrant crisis. You can read much more on this story on our website. Another former Blackhawks hockey player alleges sexual assault by the team's video coach during the team's Stanley Cup winning 2009-2010 season. The lawsuit filed last week in Cook County Circuit Court doesn't name the player who was on the team's Black Aces squad, which traveled with the team during the playoffs to fill in case of injuries, but says the team's former video coach, Brad Aldrich, used his authority to groom, harass, threaten, and assault the plaintiff.
When this is known to other players, when you are suspected of being the individual who's been abused, your other players begin to treat you differently. It makes showing up every day for practice and for playing that much more difficult. So it has certainly impacted his career, but he's willing now to take the risk of any further impact.
Attorneys for the plaintiff, who has not been named, point out that Aldrich is named in a similar lawsuit from 2021 by former player Kyle Beach. That suit has since been settled. Blackhawks declined to comment on the specifics of the latest lawsuit, but have in a statement said it takes allegations of workplace misconduct seriously and has already implemented changes like expanded mental health and new reporting mechanisms and training for employees. A surprising skipper shakeup at the friendly confines today. The Chicago Cubs announced that David Ross is out as manager, and the team didn't have to look too far to find his replacement, announcing they've hired rival Milwaukee Brewers manager Craig Counsell to the post. Counsell led Milwaukee to the postseason in 5 of the past years. His contract is reportedly for 5 years and $40 million, making him the highest paid Major League Baseball manager. Up next, the father of the alleged Highland Park parade shooter pleads guilty. What happened inside the courtroom right after this.
Chicago Tonight is made possible in part by Alexandra and John Nichols, the Jim and Kay Mabey family, the Polk Brothers Foundation, and the support of these donors.
Robert Cremo Jr., the father of the alleged Highland Park gunman, pleaded guilty today to reckless conduct. The plea came just moments before his bench trial was set to begin.
You're entering pleas of guilty to 7 counts of a Class A misdemeanor, all of which are punishable by up to a year in the county jail, a $2,500 fine, or both. Do you understand that?
Yes.
WTTW News reporter Matt Masterson was in the Lake County courtroom today and joins us now with more. Matt, what's the sentence here?
So he was sentenced to 2 years probation, which will come after he serves 60 days in the county jail there. That's going to be starting next month. He hasn't been turned into custody just yet.
Okay, so how did the father of the alleged shooter get involved in this?
So Cremo Jr., the father, was arrested after he signed an affidavit supporting his son, Robert Cremo III's application for a firearm owner's identification card, a FOID card. Cremo III was 19 at the time, so he could not get a FOID card without his parental consent. The issue, though, was that Cremo Jr. knew that that there were some substantial issues when he signed that affidavit. He knew that his son had made threats against his family, he had made suicidal threats against himself, and he had talked in the past about committing a mass shooting. This Highland Park had also been sent to the Cremo house at least twice before this affidavit was signed, and Cremo Jr. knew all this when he went ahead and signed that. So the crime he's charged with was knowing that his son posed a threat to other people, but ignoring that information to help him buy these firearms.
How common is it for parents to be charged in similar mass shooting cases like this?
Yeah, it's quite rare. The most well-known case recently, there were parents in Michigan, the parents of a school shooter there who've been charged with manslaughter. The state's attorney in Lake County also referenced a case in New York, but outside of that, it's pretty uncommon for parents to be charged in relation to something like this. Brendan Kelly, the head of the Illinois State Police, he spoke today as well. He said that the prosecution of Robert Cremo Jr. and the subsequent guilty plea were unprecedented in Illinois.
Any explanation as to why Cremo Jr. took the plea deal?
Cremo's, his attorney said his client wanted to make sure that his son, Cremo III, gets a fair trial when he goes to trial sometime in the future. That some evidence that would have come out in this case could have affected that, including snippets or transcripts from a 7-hour interview that Cremo III had with Highland Park Police after he was arrested for the shooting. That would have been admitted at this trial and gone public. It also meant that no Cremo family member had to testify at this trial. The defense had thought about calling Cremo III. That didn't happen. The prosecution had sought to bring his brother, a younger brother, in to testify. That would have happened today, but with the plea deal, that was avoided. And from the prosecution standpoint, they get some measure of accountability to ensure that there is a guilty verdict here, even without having to go to the trial.
And then, of course, the alleged gunman, Cremo III, any idea when his trial is?
It's going to likely be sometime next year. He's due back in court next month for a hearing, at which point they will set a trial date some point in the future.
Okay, Matt Masterson, you'll be keeping your eye on it for us. Thank you.
Thanks, Brandis.
And you can read Matt's full story on our website. It's all at WTTW.com/news. And as one high-profile legal battle comes to a close, Heather Sharon joins us next for details on another one just getting started. Former Alderman Ed Burke got his day in court today as jury selection got underway in his racketeering trial. It comes nearly 5 years after FBI agents raided his city hall and ward offices. But finding jurors qualified to decide the fate of the once powerful alderperson was slow going. WTTW News reporter Heather Sharon joins us now with the latest on this historic day in federal court. Heather, remind us what Ed Burke is charged with.
Well, he faces 14 counts of racketeering, bribery, and extortion. And once a jury is selected, prosecutors will argue that he used his powerful perch at City Hall to force companies and people who wanted to do business at City Hall to hire his private law firm. In all, he's charged with 4 separate criminal schemes, but the best known is probably the scheme to hold up the subsidy for the redevelopment of the old post office. He was captured on secret recordings, asking his co-conspirator, former Alderman Danny Solis, if they had, quote, landed the tuna yet. They had not, and he held up the project.
Okay, so Chicago has seen a lot of political corruption court cases. Why does this one matter?
Well, Ed Burke was really the last machine boss standing. He's accused of understanding how City Hall worked so carefully that he was able to use his power to force that. And the jury will hear arguments that was why corruption in Chicago has been able to flourish for nearly a half a century.
Okay, so set the scene for us at the Dirksen Courthouse.
So he arrived a little after 8:30 wearing a tan coat over a dark suit. He gave reporters and photographers a jaunty wave, and he headed inside accompanied by his wife, Ann Burke, the former Chief Justice of the Illinois Supreme Court, and a phalanx of lawyers. He spoke only twice in court today, once to greet the judge and once to greet the first group of 53 potential jurors who could be asked to decide his fate.
It's a lot of jurors to go through. So when will we hear, or when do we think we might hear opening statements in this case? And when might we have a verdict, Heather?
Well, so only about 24 jurors were questioned by the judge and lawyers today. Much fewer than people expected. Opening statements had been expected on Wednesday. It's not clear whether that will happen. In all, the trial is expected to take 6 weeks.
6 weeks, and as we know, there was a lot of paperwork back and forth in this trial or in this case, so a lot to work through in federal court there. Heather Sharon, thanks so much.
Thanks, Brandis.
And you can read Heather's full story on our website. It's all at WTTW.com/news. We're back with more Chicago Tonight right after this. Chicago workers could soon get 10 days of paid time off under a proposed ordinance. But opponents of the plan say it would devastate businesses if the ordinance is approved by a city council vote that could come this week. Here with more are Sophia Zaman, Executive Director of Raise the Floor Alliance, and Brad Tietz, Vice President of Government Relations and Strategy for the Chicagoland Chamber of Commerce. Thanks to you both for joining us. Sophia, let's start with you, please. You're with the organization Raise the Floor. You all support the paid leave ordinance. Tell us why.
So the paid time off ordinance would be a lifeline for the workers that Raise the Floor Alliance represents. These are predominantly Black and brown workers who labor in our low-wage industries. These are the workers that we called essential during the pandemic, who put their lives on the line to keep our society running, and who had to do so because they couldn't afford to miss work and to miss wages. So the paid time off ordinance is about respecting those workers who are the backbone of our city. It's about making sure that no one has to miss a paycheck or a job to take care of their loved ones. It's about being able to spend time with your family, going to your kid's soccer game, making memories with your ailing elders. And so this really is an ordinance that is good for workers and good for Chicago.
And briefly, give us a sense. You said, essential workers. It's been a few years since we've had to talk about it. Briefly, a couple of positions or kinds of jobs that you all represent.
Sure. So we represent workers in all low-wage sectors, whether that's manufacturing, the cleaning industry, domestic work, childcare, restaurants, food production. Again, the industries that were really essential to keeping our society running.
Brad, obviously we know some of the business organizations are concerned about this ordinance and have said that it would devastate businesses of all sizes. Tell us how.
Sure, and I do want to clarify right out of the top, though. I mean, the business community understands there's a need for a balanced paid leave policy. It's why we came to the table at the state level to do the 5 PTO days back in January of 2023. It's why we've been at the table for these negotiations. It's why we put on the table just a week and a half ago 10 paid leave policy days. Where the employer has, or where the employee has the ability to take the days as they see fit. So to Sophia's point, we understand every worker should have the need to care for themselves, care for their family, and just simply enjoy their lives. Having said that, what's before City Council, it goes too far too quickly. And it's the most complicated and expensive form of paid leave in the country. And it would acutely impact the economic development and small businesses in the communities that City Council claims to care the most about. And this is all happening on top of persistently high crime, labor, supply chain shortages, what have you, bad policies coming out of City Council, like the tip credit, for instance. I don't know if you saw this morning, but 121 restaurant owners signed on to an op-ed blasting this policy.
Removing the tips minimum wage.
Yes.
You said that it goes too far too quickly. What would you prefer to see? What would be more workable?
Well, and like I mentioned, we actually put forth a policy for 10 paid leave policy days. But one, we need a whole lot more protection from lawsuits being filed against businesses, and particularly small businesses who don't have large HR departments to push back against this. We're also pushing back strongly against the payout requirements that are required in the ordinance. So when an employee is separated from employment, unused time is required to be paid out under the ordinance. Nowhere else in the country is this required: Illinois, New York City, LA. So we're asking for a similar policy here. And we're also asking for more protections for small businesses. So the ordinance currently only exempts small businesses from the payout provisions, but we're asking for a total carve-out so that only the new state requirements apply to it.
So let's take a look at what Alderman William Hall had to say in support of this proposal.
And one thing we know is that sometimes you need to step away so that you can refresh and reset. And no one should be penalized. No one should be afraid to take time off to do what's necessary to be a good worker. And so this is a city of big shoulders. And so today we are carrying small businesses, big businesses, but all the business matters in Chicago if the working conditions are right and the wages are right.
Sophia, what do you say to some of the concerns from the business community that this would be very hard for them?
Yeah, so, I think we've heard a lot of concerns about small business owners, but I think it's important for us to ask, what about their workers? Should workers at small businesses have second-class rights? I don't think so. I think workers at small businesses should have the same rights as workers at larger businesses and major chains. Working at a small business doesn't change the fact that life happens and people need time off to take care of themselves and their families. Paid leave isn't just a benefit, it is a necessity for living a dignified life. And everyone, all workers, should have this right regardless of the size of their employer. I also want to say that this ordinance is the result of many months of negotiations, and it represents compromise. Not only did we compromise on the rollout, we compromised on the number of days, and we compromised on the payout that workers would receive. So this is an ordinance that we want to make sure is tenable for businesses, but at the end of the day, it's about giving workers the right to rest and the economic security to thrive.
Brad, you mentioned that the initial proposal called for 15 days of paid leave, and supporters have called this, quote, the bare minimum for workers. Do you not see this as a compromise? Sounds like you see this as still too much.
We have made progress through our negotiations, but it still goes too far too quickly. And I didn't mention this, but we only have 8 weeks until January 1, 2024. The state law went into effect in March of 2023, and there's calls and even legislation now to push back the effective date of the state requirements because the Illinois Department of Labor can't promulgate their rules quick enough for this. So again, you're going to be setting up businesses of all sizes to lawsuit exposure in the next 8 weeks. I don't know if you caught the hearing on Thursday, but the city officials couldn't answer the most basic of questions about this. And now they're claiming they're going to be doing trainings and rule promulgation in the next 8 weeks. It's hard for us to see that happening given how poorly drafted the language is. There's just so many, it's been a flawed process from the start, and it's leading to a flawed product. Cook County actually introduced a ordinance simply to comply with the new state requirements because in their minds, 8 weeks was not long enough to actually do this right.
Sophia, how about that? The state law that is already in effect, is that not enough?
No, and workers in Chicago are actually at risk of being behind than the rest of the state when the state law goes into effect on January 1st in 2024. Brad raised a point around the concern around frivolous lawsuits, and I think it's important to mention that private enforcement and the ability to go to the courts is fundamental, and it's a facet of many Chicago laws. We're talking about workers who are trying to provide for themselves and for their families. The idea that they would have the means or the time or the resources to recruit lawyers to lob frivolous lawsuits at their employers is beyond belief. In addition to that, private enforcement it is important because it gives workers the path to enforce their rights. What we see all the time is that employers violate workers' rights. And they don't just violate single issues, they violate many rights. The workers that we represent are dealing with unpaid wages, they're dealing with discrimination, with wage theft, with unsafe working conditions, and they face retaliation when they try to improve their workplace. And so the ability to go to the courts is also an ability to cut through the red tape of all the agencies and regulations that govern those rights. And that's so important for workers who have limited time and resources.
Brad, how might this proposal, if enacted, how might it impact businesses' ability or the city's ability to attract and retain businesses to the city?
Well, there's multiple layers to this. One, in the communities that are struggling most to economic development, I think that's where you're going to see a really big impact trying to get small businesses there, as well as big economic development opportunities. I think in the downtown area, you're going to see companies having a challenge getting workers to actually come, or like they're not going to bring workers into the downtown area because of this, if they come from the suburbs or something else like that. Because an important piece of this is the definition of employee in this only requires a worker to work for 2 weeks or 2 hours in a 2-week period to be subject to this ordinance. So, you know, for instance, a convention traveler coming in. So actually the travel industry is now kind of perking their ears up to this, because under that definition, if somebody from Seattle comes in for a convention and they're here for 3 days, they're now subject to this ordinance. So there's a lot of unanswered questions like that that we're just starting to grapple with. And our first meeting actually happened on October 13th. So we've only had 4 weeks to really negotiate this. I'm still getting emails from bigger companies being like, hey, have they considered this yet? Have they thought about this yet?
So a lot of unanswered questions, and there's the chance that City Council might be voting on this tomorrow. So I'm sure we'll be having this discussion going forward. Sophia Zaman and Brad Teets, thanks to you both for joining us. I appreciate it.
Thanks for having us.
Thank you.
And there's more Chicago Tonight just ahead, but first, a look at the weather. The city of Aurora, Illinois' second most populous, is facing a federal lawsuit over charges that it's been illegally playing favorites with the private companies that operate out of the Aurora Municipal Airport. One of those firms claims its longtime rival hasn't been held to the city's standards for aviation companies at the airport. And the firm that allegedly got a sweetheart deal has since been sold off to a business that's become a backer of Aurora's mayor. WTTW News investigative reporter Nick Blumberg joins us now with more. Nick, what's the background here?
Well, Brandis, on the one hand, this case is about a long-running business dispute, with one side saying that the city of Aurora just isn't keeping its end up. On the other hand, it shines a light on what critics of city government say is a pattern of insiders getting a leg up. JA Air relocated to the Aurora Municipal Airport more than 15 years ago. That's a city-owned airport, but private businesses lease the space and do things like refueling, maintenance, flying lessons. JA was one of 2 main aviation companies operating at the airport. The other was known as Luminaire. JA claims that for years, the city let Luminaire operate at a much lower cost than JA, putting them at a huge financial disadvantage, and they say forcing taxpayers to pick up the check for years when the airport was running at a deficit. JA also claims that Luminaire's facilities didn't even meet the minimum standards the city has in place for aviation companies operating out of the airport. Among those standards, JA says its rival, Luminaire, was allowed to use underground fuel tanks that could potentially leak and contaminate groundwater. JA and other firms must use above-ground fuel tanks to prevent a hazard like that. JA also says Luminaire's refueling facility wasn't up to snuff, with a bucket used to catch leaking fuel. Both these photos that we're seeing are exhibits in the suit.
Nick, what's been the response to the lawsuit?
Well, neither the city nor Luminaire's former owner would comment for this story, but in legal filings, attorneys for both parties have broadly denied JA's claims, saying there wasn't any unfair treatment, essentially that JA doesn't have an actionable case here. Now, interestingly, back in 2015, the city of Aurora itself decided Luminaire's business wasn't in compliance and tried to evict the company from the airport. In fact, they tried 4 separate times to evict Luminaire between 2015 and 2018. But eventually, the city and Luminaire came to an agreement and signed a new lease in 2020. That's right around the same time that, according to city documents, Luminaire's owners were negotiating with the company that would eventually buy them out.
And who's this new company?
Well, CL Enterprises is based out of Peru, Illinois. That's about 60 miles or so southwest of Aurora. It's a holding company. They have firms that do a whole range of things: wood products, chemicals, aviation in Aurora and in other cities. It bought out Luminaire in 2021. It's since signed an updated lease with the city, a lease that JA says in its lawsuit still contains those illegal sweetheart terms. Now, the company is also developing a brew pub in downtown Aurora in a building that it bought from the city for $1, a deal that also includes a $900,000 taxpayer-backed forgivable loan. Now, since coming to Aurora, CLE's owners have become big backers of Mayor Richard Irvin. State records show they donated nearly $5,000 to his campaign fund earlier this year. The company also played host to the annual State of the City address at its airport hangar, and then weeks later hosted a political fundraiser for Mayor Irvin in that same space out at the municipal airport. That fits with what critics say is a long-running pattern of people and businesses getting taxpayer-funded deals, contracts, and other benefits from the city, who also back the mayor and his allies. That's a pattern WTTW News has been reporting on over the last couple years. Now, for its part, the CEO of CL Enterprises told us while it's not a party to the airport lawsuit, it's been operating above board, that it's the company's responsibility to support local leaders interested in economic development, and that any benefits it's received are comparable to other common redevelopment deals. Brandis, it's a twisty story. There is much more to dig into online.
Sounds like it. Great reporting, Nick Blumberg. Thanks so much.
Thank you.
And you can read Nick's full story on our website. It's all at WTTW.com/news. And that is our show for this Monday night. Join us tomorrow night at 5:30 and a special time, 11. And we'll leave you tonight with Chicago's Christmas tree arriving in Millennium Park today. Now, for all of us here at Chicago Tonight, I'm Brandis Friedman. Thanks for watching. Stay healthy and safe, and have a good night.
Closed captioning is made possible by Robert A. Clifford and Clifford Law Offices, a Chicago personal injury and wrongful death firm that is committed to supporting diversity, equity, and inclusion initiatives throughout the legal profession.